and Lee for attending the NASBA regional meeting. It was great to have our board attorney there. And Lee, I think you found it very informative, but we were very pleased to have you with us. So thank you for taking the time to do that. NASBA Treasurer Andy Bonner will give us a NASBA update later today. But Jen, you have given us some statistics from NASBA on the CPA exam pass rate. So it's very interesting to me. And this was discussed some. It was preliminary information at the NASBA regional meeting, but the discipline sections of the CPA exam, we have quite a the numbers vary significantly, I think, from the three sections. So I know NASBA and AICPA are working on that and looking at it. That's nothing you can control, but it's just interesting information. The tax section, I think, has been the one that has had a real high pass rate, and maybe the bar has been low. Is that a fair assessment, Andy?
Very fair statement. I've got some statistics on there that will surprise you when we get to that part. But it's just the exam has really been exciting this year in the fact that our pass rates are up over 50% in the first and second quarter. They announced that at the board meeting last week. So it's good to see and it's good to hear. But there's a lot of things that we're looking at to help to see what's going on in the exam, and I'll update that later.
Good. I just wanted to touch on that since some of that information is in Jen's report. Any comments or questions for Jen? Okay, I think we have an action item. We need to approve the two proposed dates for board meetings. So at this point, we would entertain a motion to approve those dates.
So moved.
Second.
So moved. Second. All in favor, aye?
Aye.
Those opposed, nay? Okay, thank you. Next on the agenda is a legislative update, and I think, Lee, you were going to present that for us?
Yes, sir. Briefly, the Less is More Act of 2025 has now been signed into law. The provisions regarding accounting, for the most part, became effective July 1st. There is a provision regarding the initial pathway and an additional initial pathway that has been made into law, and it will become effective January 1, 2026. Secondly, there is a new set of rules coming online with the peer review chapter of the board's rules. Of course, this board approved those amendments to the peer review rules, and they will become effective September 28th of this year. That's all.
Question, if I could. Lee, I know that in the past, we could not have virtual meetings. Did the law change anything about having virtual meetings or with the passage of the governor's bill?
Yes. Less is More included a provision under which boards are only required to meet in person once annually. So previously, I'm trying to recall if the Board of Accountancies had an instance of this recently where, for example, if you all had to hold a meeting virtually because it snowed and you couldn't make it to Nashville, required some paperwork to fill out to hold a virtual meeting, that's no longer required. You can hold a virtual meeting for any purpose so long as you meet at least once in person.
All right, thank you. I was excited about that. I thought, there's been times since I've been on the board that maybe we needed to have a quick meeting to further something along so we can get it faster, and now we can actually, I believe, have a call meeting and do it between the quarters if we need to.
That's correct. You'd still have to provide proper notice, of course. But yes, and the department has no intention of developing any sort of policy for our boards to adhere to in this. So it's the discretion of the board how you'd like to utilize and when you'd like to utilize virtual meetings.
Appreciate it. Thank you.
Other questions or comments? Okay. Thank you very much, Lee. We will move to our board committee reports, and we will start with the licensing committee chaired by Dr. Pam Church.
Thank you. We have 5 requests for extensions on parts of the CPA exam. The licensing committee considered these yesterday and passed motions to accept all of these. So Karen, am I correct that we can go through all 5 and vote at the end?
Yes, I believe you can.
All right. And I want to point out that we've started a new way of presenting these that I think is a positive change. We will be presenting the cases anonymously. Now, needless to say, Jen and the staff have the details as required, including name, but we will not be presenting the name here. I want to begin by reading the applicable statute, the rule that these fall under. So Board Rule 0020-01-.066E states the following. Notwithstanding subsections A, B, and C of this rule, the period of time in which to pass all required test sections of the examination may be extended by the board upon a showing that the credit was lost by reason of individual hardship, including but not limited to health, military service, distribution at a local, regional, or national level impacting the disruption, not distribution, disruption at a local, regional, or national level impacting the candidate, or other circumstances beyond the candidate's control. So that's important, beyond the control, and certainly of an extenuating nature. So our first case, number 1, CPA candidate has requested that the board consider an extension of his auditing score from an expiration date of 6/30/25 to 8/30/25. This person contacted the board May the 5th, requesting this 2-month extension, and noted that over the past several months prior to this request, he'd been traveling to Pakistan to provide care for his mother, who recently suffered a serious spinal injury. He had requested another extension for the same reason previously and was granted an automatic extension with so many others to 6/23, no, that's not right, 6/30/25. So this is a new request, and we did go forward with a motion to approve that. The second one, candidate requested that the board consider a 10-month extension of reg from expiration of 6/30/25 to 5/2/26. This person contacted the board May 27th, 2025 with this request. An expiration date of 5/20/26, which is what she is requesting, would align with expiration of her other past section FAR. Her extenuating factors are high blood pressure, and that has affected her ability to balance work and study, and then new persistent daily headache that's an ongoing issue requiring follow-up by specialists. So again, we are moving that we accept that extension, approve that extension. The third one, request number 3, this candidate has requested that the board consider a 9-month extension of FAR from an expiration date of 6/30/25 to 3/31/26. This candidate contacted the board May 30th, 25, requesting this, noting she had several significant hardships, including hospitalization from motor vehicle accident, tonsillectomy, rotator cuff surgery, unexpected loss of her sister, and hysterectomy. So in light of these multiple extenuating circumstances, we are moving that this request be approved. Number 4, this candidate requested the board consider an additional extension of reg and audit from an expiration date of 8/31 to 12/31/25. The board voted to approve an extension of these from 6/30/25 to 8/31/25 at our most recent meeting. And I will say, we noted at the time, that was a relatively short extension. And in fact, the medical situation has persisted, the one that was the basis for our approval, which has led to this additional request, and this candidate has submitted documentation from his doctor, so we are moving to approve that. And finally, request number 5, this candidate requested the board consider a 6-month extension of audit from an expiration date of 6/30/25 to 12/31/25. Contacted the board May 15th, 25, requesting this extension, and provided a letter noting that she has complications with her pregnancy, which is ongoing and has led to this request. We are moving that we approve this. Any discussion of any of these? Karen, can we do a voice vote, or do we need to?
Yes, ma'am.
All right. So all in, I'm sorry.
Just to clarify, since the recommendation is from the committee, we do not need a second,
Correct.
so go
Thank
ahead.
you.
Yep.
All in favor of approving these 5 candidates' requests, please say aye.
Aye.
Opposed? That concludes our report.
Thank you very much. Mr. Griesbeck, law and rules.
Thank you, Mr. Chairman. Pursuant to Section 62-1-105 of the Tennessee Code, the Tennessee State Board of Accountancy has authority to adopt and amend rules governing its administration and enforcement of the Tennessee Accountancy Act. Most recently, the board amended its rules regarding the peer review process in Tennessee, and those amendments will appear in Chapter 6 of the board's rules with an effective date of September 28, 2025, as mentioned earlier. Now, in a continuing effort to maintain rules for the administration and enforcement of the Act, the board should consider additional amendments to its rules. In particular, the board should consider amendments in Chapters 1 through 5. These amendments are necessary to complete the retrospective review process required by the Uniform Administrative Procedures Act. The amendments are also required to incorporate relevant provisions of the Less is More Act of 2025, which was enacted into law during the most recent session of the Tennessee General Assembly. In the board's materials for today's meeting, you will find a draft of proposed amendments prepared by board staff and legal. The board will not be voting on these specific amendments today. Today, the board is merely commencing the rulemaking process, and the purpose of the draft in your materials is to describe the general scope of amendments to be considered. Yesterday, the committee heard from Ms. Binkley, who walked us through the various changes to the rules that are in the packet before you. And after discussion, the committee voted to commence the rulemaking process related to these proposed amendments. Mr. Chairman, we would ask that, or suggest, recommend that this matter be put to a vote of the full board.
Thank you, Mr. Griesbeck. And again, we are only authorizing the commencement of the rulemaking process, and so we're not voting on the specific changes. So again, we do not need a second since it comes from a committee. Those in favor say aye. Aye. Those opposed, no. Thank you, sir.
The additional item the committee considered yesterday was revisions to a discipline matrix that the board and staff used to impose various penalties, discipline, I'll say, for various violations of the law or rules. And Mr. Lott walked us through these. We've discussed them several times over the course of the last 6 to 12 months or so. And the narrative particularly that sort of serves as guidelines for us, or introduces the guidelines, there were some changes made to it. Very importantly, the guidelines do not contain every violation or form of discipline possible under the law and rules of the Tennessee State Board of Accountancy. And also, it very clearly that the board may also assess the actual and reasonable cost of the investigation, prosecution, and hearing of any disciplinary action held in accordance with the contested case provisions of Tennessee's Uniform Administrative Procedures Act. We considered and reviewed some of the various changes that Mr. Lott passed on to us, and at the end of our time review and discussion, the committee voted to recommend to the board approval of the revised discipline guidelines as set forth. So I'll pass it on to you for
Great.
approval.
Thank you. So those in favor of the proposal, say aye.
Aye.
Those opposed, nay. The ayes have it. Thank you. Anything
And
else?
we'd just like to thank Ms. Binkley and Mr. Lott and any other staff for their work on this for us to consider. It was well done.
Thank you, Mr. Griesbach. And now we'll turn.
Mr. Chairman?
Yes, sir.
May I
Sir.
ask a question real
Yes,
quick?
sir, absolutely.
I know yesterday in our committee meetings, you had talked about, when we got specifically to the violations, about different ways that people violate when, for example, if they do a test engagement and they are not authorized or are not in peer review or have not gotten a license to be doing a test work. And I thought about that last night, and I thought, there, just off the cuff here, you can think of, I thought of 4 different ways. It actually can be more than that, because I'm really concerned about people who are not paying attention to the fact that you have to register, you have to get in peer review, and you have to do other things professionally. And so I went through last night and kind of looked. I said, first of all, they violated the code, which is required to follow the code. Secondly, they signed off on an engagement being independent when they weren't, because they weren't even allowed to perform the test work. Secondly, they signed on signed the test engagement. So, and then thirdly, they signed a statement with the state of Tennessee that said that they would not be doing any test work. And so I think that we, in the past, we haven't considered all the independence violations, that they've done. We haven't considered the other items, and I think that as we go through this, if we could kind of focus on that and take a look at that, because I think there's I know that in this board, there's been a lot of concern about people saying, hey, well, do the work and pay the $1,000 fine, and it's about public protection. And it just, I think if you do something that you issue a report and you're not authorized to issue a report, there should be a larger penalty for it. And I encourage us to look outside the box at that and take notice.
Thank you for those comments, Andy. As I think most members of the board know, I share those same concerns. I've voiced those publicly before, and so I think those are very important points. Thank you for bringing that to our attention. Other comments?
Mr. Chairman, I have a question
Yes, sir.
actually on this. Is this, now that this has been topic for several meetings now, is this available publicly on the board's website, this matrix that we are discussing? And if not, should it be?
It is not currently available, and I think that's something we can circle up internally and see if it's something that we can make available.
Good point. Thank you. Other questions, comments?
Mr. Chairman, on that, I agree with making it available on the website, but I also think we should have language surrounding that. These are guidelines, and so the board has discretion. There may be other types of violations that aren't explicitly mentioned in the matrix that we will have to deal with at some point, and so this is an effort at I think as Chairman Griesbach said yesterday, trying to be reasonably consistent with the way that discipline is meted out, and but there will always be extenuating types of violations that we'll just have to basically deal with as they arise. And I think as long as it's made clear that these are guidelines and that the board has discretion within the parameters of the law to act, I think that'd be very appropriate.
Other comments? Okay, we will move to the Enforcement Committee. Chairman Kevin Monroe.
Thanks, Mr. Chairman. So yesterday, the Enforcement Committee met, and we reviewed an information-only case and complaint report. This is a report that staff of the board utilizes to manage our history of cases that have not been completely resolved. And in the vast majority of the circumstances, the most aged cases are those that have been placed in litigation or legal monitoring. And the reason for that is because there are court proceedings generally associated with those cases, and our action will have to occur after those types of matters are basically dealt with. In addition, as noted yesterday, the case and complaint report does not include any of the disciplinary cases that we're about to address when we get to the legal report in just a second. So that was an information item, and it just keeps the board members apprised of the status of outstanding cases. The next item is our legal report, and this is the situation where the Enforcement Committee reviews and makes recommendations on potential discipline for complaints that are submitted to the board by others or that the board staff itself opens, for example, as a result of a CPE audit deficiency. That would typically result in the opening of a complaint if it's not resolved appropriately. In this particular case, there are three types of cases that the committee and the board deal with. We have what we call consent items. That's what we have on the agenda today, where no formal proposed discipline is recommended. We have then a tranche of potential cases where proposed discipline in the form of civil penalties or signing a consent order are recommended, and then occasionally we'll have representation cases where something has changed in the facts or circumstances of a case that we've already dealt with that requires further action on our part. So today, all we're dealing with are consent item cases. The board discussed each of these in detail yesterday. I should say the committee did. And I'll just briefly highlight the types of cases so that it's clear what we're dealing with. Typically, complaints in this bucket of cases for recommendation without discipline are either because we don't have jurisdiction to deal with the case, and it may be a fee dispute. So when a client and a respondent or a complainant and a respondent are arguing over fees, that's not something that this board mediates. That is outside of our jurisdiction. Additionally, lack of jurisdiction may take place where the respondent is a non-CPA, and as long as they're not performing activity that would require a license, typically, we would close with lack of jurisdiction because we generally are tasked with regulating CPAs unless non-CPAs are inappropriately holding themselves out as CPAs or performing those kinds of actions. And we have two of those cases in this group today. We have a case that was of interesting to note, and I'll just bring this up for public awareness. We actually had a case where a complaint was opened based on a review report that had been issued in connection with the contractor's licensing board requirements. And as it turned out upon investigation, when we contacted the respondent about that review report, it became clear that that respondent had never issued such a report. Someone had basically utilized the respondent's name on their behalf, and they had gotten through that, but as it related to the complaint that was originally opened against the respondent, they had never issued such a report, and steps were taken to try to address that at the website level, but that's really beyond the respondent's or our control. So that case is recommended for closure with no violation. We have a couple of cases that are closed with a letter of instruction or warning, actually three, basically with respect to usage of the term accountant or accounting in title or designation, which is not permitted under the statute. And generally, when we have that and the respondent voluntarily agrees to address that promptly, that will result in a letter of instruction or a letter of warning, but no formal proposed discipline, and that is what has been the case in a couple of these cases here. And then we had a nuanced discussion yesterday about there was a complaint that was opened with respect to an entity that was inappropriately using the term accountant or accounting for title and designation. They agreed to clean that up promptly, and so that was fine. But in addition, on their website, they were advertising for the provision of accounting services, not really using that in the context of a person's title or designation. And when we looked at the description of the services, those were very permissible services for a non-CPA to perform. And so we talked about the nuances of that, and because it was not using that term in the context of a title or designation associated with a firm or an individual, it was determined that that was not in violation of the current rules or statutes. So that summarizes the cases that we had. In each of the cases, the Enforcement Committee recommended approval of the recommendations here, which are to close either for lack of jurisdiction, for non-violation, or close with a letter of warning or instruction when those violations were cleaned up immediately in terms of use of improper designations.
Thank you, Mr. Chairman. Are there questions, comments? Okay, once again, we do not need a second to approve the motion. So those in favor, please say aye. Aye. Those opposed, nay. Thank you.
And Mr. Chairman, one last comment, just a thank you to the staff, legal counsel, and investigative counsel for the board. They really work hard to get this right and to bring cases that are well researched and well thought through when we do actually have to promote discipline. And so just appreciate all the work on their parts very much.
Thank you. Next is the Executive Committee report, and I will ask our Executive Director, Jen Binkley, to present a couple reports for us.
Yes, happy to. Thank you, Mr. Chairman. So yesterday in the committee meeting, we went through travel details as well as financial results through the end of May. I'll recap. Travel detail from calendar Q2 2025 includes Duke's travel for the May board meeting, as well as my and Duke's travel to the TSCPA's annual meeting and convention in Chattanooga, and my travel to Philadelphia for the NASBA Eastern Regional meeting. I had mentioned yesterday that I had financial results through the end of the year. I did not provide a detailed update to your board meeting materials because I haven't yet had a chance to fully review them. But I will say we are, as it stands, we do have a couple of closed periods to get through where we may see a little bit of fluctuation. But for the fiscal year ended June 30th, 2025, our board was in a deficit of $77,868. So I'll provide, if there's any additional detail or context to provide, I'll give that update in the October meeting. At this time, I'm happy to take any questions about either of those two items.
Questions or comments? Okay.
Thank you.
Thank you, Jen. And once again, I've said this several times, but thank you for the travel. I think the outreach is important. And Duke, thank you for your involvement this past quarter. And again, Lee, thank you for attending the NASBA regional meeting. It's very important, I think, that we be involved in the profession and what's going on. So thank each of you. At this point, I would ask NASBA Treasurer and Board Member Andy Bonner to present a report from NASBA.
Thank you, Mr. Chairman. I was blessed to be a part of the board meeting last Friday with NASBA, our July meeting. We went through several updates. There's just so much exciting stuff happening at NASBA right now, and they're really stepping up to the plate and trying to help the boards of accountancies with things that are concerning us. One of the things that we went through in detail was private equity task force, also sometimes referred to as alternative practice structures. And I thought that this was very interesting, and so I've got some detailed notes here. It says that we formed a task force in NASPA to really look at it and to help the boards and the executive directors with a lot of questions that are being raised. The task force has been established for evaluating private equity ownerships and CPA firm structures, focusing on regulatory concerns and implications for independence and public trust. Dan Vokowicz actually told us about the task force highlights. They're looking at the complex ownership structures, and what we have found is there's a numerous amount of different structures that are being developed. It depends on which attorney's writing it up. The structure's kind of different, and that there's no uniformity, and really it really complicates the regulatory oversight. The legal research is being conducted to analyze the state laws and rules regarding the non-licensee ownership and activity of individual participation, and whether it's natural persons or not, and the moral requirements really associated with them. Concerns were raised about private equity firms potentially undermining our independence. The task force is developing a template for key questions for state boards to use. And really, in doing that, they're going to come out with that, and it's going to be at our annual meeting in October that they're going to present a lot of this, what the task force has come up with. But they're going to come up with a list of questions that boards may want to use to understand firm structures and ownerships. And they kind of emphasize the importance of that, just kind of get their hand around it, because Peak is in the process of coming out with a paper for comment about the independence issues associated with these alternative practice structures. In fact, for the first time, one of the few times ever, Peak actually just asked for comments associated with the structures before they came out with a comment period for the new disclosure. The other thing that they're doing is they're coming up with a white paper for state boards. A white paper is being drafted as an educational tool for state boards to understand private equity ownership issues. They're very close to getting this white paper finished. They plan on including the risks and concerns and potential solutions associated with it. They plan on actually issuing this white paper next month and then presenting it at the annual meeting. And so that here again, another reason that that Jen and Lee has been actively involved in those meetings and attending, because it really is going to, I think that they're really going to get some great information at the annual meeting. One of the things that we discussed when they were talking about the committee and the committee itself, or the task force, discuss the role of peer review and monitoring independence and quality management in private equity firms or private equity-owned firms, emphasizing the need for robust documentation and adherence to the standards. It was noted that the AICPA is actively discussing private equity ownership within the peer review context and is and not yet made any specific decisions. But we heard a lot of private equity groups are looking at their new quality management documents to address independence and prepare for the upcoming reviews if they have gone to that realm of the alternative practice structure. They're also establishing a dialogue with private equity industry groups to address regulatory concerns and fostering mutual understanding. So that a big part of our board meetings was, and we had a lot of discussion in this area. This is just a tip of the iceberg. We probably spent an hour and a half on this area at the board meeting. And so NASPA heard the call and heard from the executive directors across the 55 jurisdictions and said, hey, we need to really start looking at this independently of the AICPA to give some guidance to our boards. And so I applaud them on that. The other things that we learned was there's an exposure draft on a proposed statement of standards for CPE programs. So you're going to have AICPA and NASPA come together. They've got an exposure draft. I encourage everybody to read that. If you recall on the board, last time we had a change to CPE programs, we actually came to this board and then redid our rules associated with them. And so it's something that we'll all be involved in. So I encourage not only individually, but our board maybe to consider commenting on that exposure draft. The CPA exam pass rates and sections. We spent a lot of time in this area. A lot of people are concerned with some of the lower rates or pass scores that we've had, and especially in the new disciplines area. And I thought that we were all talking. The exam has changed so much, from when we took it, and you could take it 2 times a year, and you went to a place that didn't have bathrooms, and birds were flying around above you, as Robert Vance has reported before. But I thought I would just kind of go through. I mean, for younger CPAs that are taking the exam or just passed it, they're probably saying, "Yeah, y'all don't know this," and I know it, but we talk about FAR and BAR and auditing. And so I thought I would just kind of break it down real quick. As far as the financial accounting and reporting, it's a core. Auditing was auditing and reporting, and then you got reg, which is regulations for federal taxation and business law. And then you come to the disciplines. And of course, BAR has gotten a lot of attention in the disciplines for the low pass rates, and that's business analysis and reporting, and that's pretty broad. I mean, you're talking about nonprofit, you're talking about governmental, and so it's been really tough in that area. And we actually talked a little bit about on one of the breaks that we had at NASBA about, that most everybody is on the public side, and they're not dealing with the nonprofits and the not a lot of people deal with the nonprofits with the governmental side, and if there's a heavy emphasis on that, that probably affects the test grade. And then we came over and you got the ISC, which is the Information Systems and Controls, and the TCP, which is the Tax Compliance and Planning. And then we got into just some things that are happening. The first one was, as I already said earlier, we actually got the second quarter results, and if you look at the pass rate percentages, they were up 50% on the first and second quarter for this year. So a dramatic improvement. It looks like that people are studying more and maybe focusing instead of just trying to take the test quick. It said here that the BAR portion of the exam had a 9-point increase and an 11-point increase in the ISC sections, and thus, they seem to be very prepared for those sections. The ISC section pass rates improved due to the focus on multiple choice questions and SOC engagements, making it a preferred choice for candidates. So if you go out to the website, the candidates are already figuring out, hey, you want to take these, don't take these. And you can, in a second, I'll give you some of those rates. The concern was raised about FAR because the pass rates being the lowest, and this is what we've learned is that 60% of the candidates failing FAR never go back and retake the exam again. So if you're a candidate, you're thinking about taking the exam, do FAR last. Get some confidence in the exam maybe. But it just seems like that one is just really disappointing to see that 60% of the people who fail it would never come back and take the exam again. Some jurisdictions, candidates are avoiding BAR, like I said, and opting to take ISC and TCP. And really the ISC and TCP, this last quarter, ISC had a 72 pass rate. And I think if you think about when we took the exam back years ago, that's a pretty high percentage. I don't think I've ever seen a percentage that high. And TSCPA had a 81%. So with BAR being in 47% and the previous quarter 38%, you can see why people are kind of jumping to those other parts of the exam. And then FAR, I was just stunned at this. The first quarter of this year, FAR had a 42% pass rate, and the second quarter they had a 44% pass rate. So the BOE is actively reviewing pass rate discrepancies and or really disparities and across the sections and considering strategies in this area, just to address some of the questions that people have been having there. we learned that the CPA exam operations at Guam is kind of transitioning. Guam University is going to take over the exam part there. NASBA will be shutting down really the operations in October, and actually 2 of the staff is going to be replaced with 2 more people in Nashville, Tennessee. So you'll see 2 more employees over there. The exam security was talked about a lot. We got a detailed update on exam security, including communication processes between the AICPA, NASBA, and the boards of accountancy. And then I know that a lot of the EDs are excited to hear about, but the ALD rewrite. I have been blessed to be a part of that committee or that task force, and we're going to actually release release 1 of the core is expected in August. It's actually being beta tested right now, and then it's going to be followed by 1.A is going to be released in August, and 1.B is going to be released probably in September, and that's going to be really a tool for NASBA to use internally to increase the efficiency of helping load it up, and then also helping the executive directors. One of the more exciting part was that since I've been on the board at NASBA, we've all been trying to get Hawaii to participate in the ALD, and Hawaii has agreed to participate. So we were really excited about that. And we got a lot of, I know that we always have an investment committee meeting, and everybody wants to know how people are using AI. And when we had our investment committee meeting, Morgan Stanley Group kind of gave us an update on how AI was being used in trading, which was, amazing to me, how they think through the box, and they went through and they're using that as a tool in that area. NASBA has gotten on board, and they're talking about several key technology projects. One of them is NASBot is what they're calling it, a closed loop within NASBA to help with customer service. They're also going to start testing Chat GPT-4, which is a closed loop, and to look at efficiency and future applications. They've actually got a control group over there that is exploring that and looking at how to explore those gains and really the functionality of it within the organization. We have the mobile app coming out for candidates, and that's exciting. It's also going to have a September 30th deadline to be active, and we talked a lot about that. Bill Emmer and his group. I mean, it's just amazing the IT projects that NASBA has taken on in this year, and all the projects that they've started and it's going to finish this year. And we talked a lot about that area. One of the things that they've done is, we've got CPA mobility, and AICPA and NASBA have come together, and it really talks about your principal place of business. You can actually go to the app and look at it. What it does is it allows you to go on, and it says, where's your principal place of business? That's the first thing it asks you. The second thing it asks you is, where will you perform services in person, either or by mail, telephone, or electronic means. You pick that state, and then it says what type of services you plan to perform. And when you do that, then it'll come up and say, these are the requirements for you to be mobile in that state, which is what a great tool to have. And then, we've got new pathways. And so there's a lot of people asking about pathways. NASBA actually has on their website a new licensure pathway that really comes up. It's a map of the United States, and there's green states where pathways have actually been signed into law, and the executive directors for those jurisdictions / states have gone out and said, this is what's required in our state for a new pathway. And they actually took a lot of time in going through and asking. Tennessee is one. They got in touch with Jen, asked her, is this correct? And she said, yes, she signed off on it. And now you can go see that map, you can drill down to which state you want. I think there's 22 on there now that have been completed. And then it'll tell you what the new pathway is and all the specifics about that state. And you can find that on the NASBA website. It's just, in my opinion, the ability to get information out and the ability for candidates to understand it and or as a firm to understand what your new employees need to become a CPA, and that access is there, and it's quite exciting. I know that 4 states have signed legislation, but we're awaiting confirmation of summary information. So we've got 4 more states that are probably going to pop onto that website. As Jen said earlier, the 118th board and annual meeting, we always do that board meeting with the annual. That's going to be in Chicago. It's downtown. I think it's the Sheraton downtown, which is close to the Miracle Mile and Navy Pier. And so encourage everybody to consider that and possibly attend. And so that's all I have.
Thank you, Andy. Very informative. We've touched on several of the topics that were covered at the NASBA regional meeting. And one of the things you maybe touched on this a little bit, but your NASBA board member colleague, Barry, I've forgotten Barry's last name, with Mayor Hoffman, or CBiz?
Yeah.
Berkowitz. Yeah.
Thank you.
So Larry, or Barry rather,
Barry,
agreed to sit in on a session at the regional meeting and talk about the alternative practice structure, which he is definitely involved in. And I really appreciate him doing that because he was really on the firing line because, as you might note, some folks are very much opposed to alternative practice structures and the effect on independence and so forth. And but he stepped up to the plate and talked through some of that and had some questions. And so I really was appreciative of him doing that.
Actually, Barry's on our task force, and really when we got in discussion of it, we had 3 or 4 members of the board that were on the task force present, and we had a robust discussion of things that they're concerned about. So they really gave us a list of things that they were looking at, the concern at, and they were really digging into, so we can get some good information for the executive directors and the jurisdictions.
And these are important. It will be important for our board to continue to monitor, and at some point the professional will have to decide where we're going on this. But I just did a quick search a second ago, and it was in July of last year that CBiz acquired Markham. I think it was for $2.3 billion. So there are some big transactions occurring nationwide, and so we'll continue to monitor. And also thank you for the update on the test scores. That's very important, I think. So.
I thought that the FAR thing just blew me away. I didn't realize that people were just getting so down on it that if 60% of the people who fail it are not even coming back, I mean, really, push FAR off to the last one if you can. There are other parts of the exam that could easily be fit in, but it seems to be the toughest one people are having with.
I would add that when you look at FAR, that's a good example. It covers a lot of different topics. And before the changes in the exam format, there was more of a direct connection. I'm not saying this is a bad thing, but there was more of a direct connection between specific courses at the undergraduate or graduate level leading to and coordinating with certain parts of the exam. And Kevin, with the UAA, of course, it's very helpful that we now have different topics that are differentiated for each one. But I think there should be communication. I'm sure there is, but I would encourage more communication with colleges and universities to get their input about what they're hearing from students. Are the students prepared for FAR when they take FAR? And which, are there parts that are just not even in the curriculum of certain colleges? So not-for-profit is a good example, In the past, students didn't even take not-for-profit. I can tell you from teaching governmental and not-for-profit for years, not-for-profit's a tiny little part of the textbook usually. And so is it a disproportionate representation on the exam versus what they're getting in their curriculum? And I have struggled as a professor at a small school where we teach so many different topics. I've struggled with knowing what path to define for students is when you build a curriculum. So we don't want the exam to filter out good candidates because they can't determine what to study or the schools cannot determine what to teach. I think a clear path is very important, and I think some professions have a clearer path than we historically have.
Dr. Church, I think you make an excellent point. I mean, really, the BOE is talking about the fact that it seems like you had a lot of courses. I know when I was in college, I took a nonprofit course and also a governmental course in part of my 120 hours. I wasn't in the 150, I was in the 120. And that really helped me with the exam. And actually, it was a nonprofit question that I blew out on the exam. I was like, all right, this is right what I remember from school. And had not even studied that area. And so I think that a lot of colleges, there's been so many changes so fast, I think that we need to slow down and look back to see. And maybe it's that, I'm hoping it's just that one little group that maybe got left out a little bit there. But I will tell you that we discussed in the board meeting OBA, or the Act, but the One Big Beautiful Bill Act, that there's so many changes on the tax side there that they're having to rewrite the entire exam on tax. And I was like, wow, I didn't realize that. And so they're very quickly starting to do that. They say that most of the questions on the exam are going to have to be redone. So I just think there's been so many changes so fast that everybody's starting to say, wait a second, we need to pull back and see what's on the exam and make sure that it does kind of fit in with what people are being taught in college. And so hopefully I know that a lot of people are looking at it. The AICPA is concerned, NASPA is concerned, BOE is concerned. And so I'd say that we're going to hear a lot more about that. And I was told that we're going to hear a lot more about that in the annual meeting. Another reason, to consider that. So, but thank you for your comments.
Other comments or questions? Thank you, Andy, and thank you for your involvement in NASBA. And not only Andy, but many of you also serve on NASBA committees. So I would ask at this point if anyone has an update from your NASBA committee.
Thanks, Mr. Chairman. The NASBA committee that I serve on is the UAA committee, or the Uniform Accountancy Act committee. It's a joint committee with NASBA and the AICPA. And the committee's task is to curate and recommend to the boards of both of those organizations changes to the UAA, which is a model rule. States are not obligated to follow it, but it is a model rule that provides, I think, some common framework. And many states do opt to follow it fairly closely. And so during this past year and a half or so, actually probably 2 years, we've been working on two sections of the rule, sections 5 and 23. And they essentially relate to the pathway and to mobility. And so the way I would describe it is 2.5 years ago, the predominant position, I think, was, I would describe it as retain the 150-hour requirement or give me death. I mean, that was where people were planting the flag. And then with the pipeline issues that are besetting the profession and the industry, that morphed away. And then the flag planting was relating to, give me mobility or reciprocity, or give me death. And so that's where things have kind of moved to. And so the UAA, I think this month, they published now the 9th version of the UAA, or edition of the UAA, that basically allows or now formally provides for that alternative pathway whereby while you can continue to get 150 hours or a master's degree and have 1 year of experience, you can now basically, in the model rule, deal with a bachelor's degree and 2 years of experience. And of course, our legislature earlier this session in the governor's key piece of legislation basically passed elements of that in the bill that he recently signed into law, which now provides for that alternative pathway for our Tennessee-based potential new licensees. So glad to hear that. The UAA does a lot more than just that aspect of it, and so we'll have a pretty full plate in the upcoming year. But really our task has been to try to get those sections of the model rule accommodating that and providing for, among other things, for mobility. The model rule provides basically for a grandfather period. So those that were licensed in what we would call the substantial equivalency era, are going forward going to retain their practice privileges and mobility privileges going forward, and then providing for a means of mobility which is basically switched from a substantial equivalency model at the state level or jurisdiction level to an individual mobility model. Now, for us as regulators and for the staff of our board, that's going to require a little bit more work as we deal with folks that are seeking to practice in our state under our rules, because we'll have to do a little bit more than we did before. We can't just say, well, what state did you come from? And, oh, yes, that was a substantially equivalent state, no worries. We'll have to look at individual qualifications. And so for new reciprocal licensees, we'll have to address that and develop mechanisms for that. But I think progress has been made, and hopefully our pipeline issues will be lessened as a result of the flexibility that's now being offered.
It's very important work that you've done, Kevin. Thank you for participating in that committee.
Mr. Chairman, the UAA committee has done a fantastic job, and Kevin's been a real leader on that committee. And I've had a lot of people on the board come up and talk about Kevin's input and everything related to that. And just want to thank Kevin for his service on that committee, because they have really had a lot of meetings and been very involved in the pathways and mobility and all the changes that have been happening. And one of the things that kind of highlights what they've done is I know Jen's got a map that she can pass out to everybody that talks about the different states and jurisdictions that have actually signed in the either a pathway or a mobility via legislation or rule. And I thought it was kind of interesting when you get into this, because this is what this was just updated on July the 25th. It really does highlight how many changes are happening across the country in this area. And really what the UAA, a lot of people have followed the UAA, but some of the changes in the law and or by rule happened before the UAA kind of came together and finalized that. And I applaud, Kevin and the group for coming together and doing that. If you look down, you can see that there's effectively 20 states that have already signed it into law. Obviously, Tennessee being one of them. There's 10 different states that the law doesn't really take effect until after 2026. Tennessee actually was effective on 7/1 of 25 for the pathways. And you can see that the two states, Maryland and Florida, the legislation did not advance. And then there's 3 states where it passed both chambers. One of the more interesting areas is just in Michigan. Their pathway legislation, which is not supported by the board or the CPA Society, calls for an associate degree, which would allow somebody to get a CPA. And really, and that's the first we've heard in that area with an associate degree, a 2-year degree, that would be allowed to sit for the exam, which is, you know, if you think the pass rate's low now, I don't know what you can learn in 2 years. It can be more that would help in that area, and I really am shocked at that. But this is kind of a map of what's going on, and with mobility and pathways together that that NAS was put out and shared with Jen, and so I thought that would be a great segue with the UAA to show that.
And can I just add a quick point of clarification? So NASBA has been a great resource to the executive director community in keeping us apprised of what is happening with other states, and they have been communicative with me, especially as it relates to Tennessee, with the mobility changes happening on July 1st of this year, and then the new pathway coming in on 1/1/26. So we have been in sync on getting those updates from Tennessee to them, and it's been a great resource for us.
Greg, I can talk about the education committee. Thank you. I'm on the NASBA Education Committee. We had a relatively short virtual meeting that was focused entirely on research projects we might like to encourage for the future. And generally, these focused on the things we've talked about today, the changes our profession is facing, the challenges that we're facing, and of course, the new changes in experience in education are important. So we talked about research projects that might compare pass rates under the two pathways. In a way, as people pointed out, it's a little too early for that because you're not going to have enough data for a while, but also maybe too late for that if you were trying to support the changes. But of course, there's been research. But here's something that I pointed out that I hope you'll keep in mind. NASBA annually for years published their, what's it called, candidates report, and schools got that broken down where they could see how their students had done in relation to those in the state and those in the nation, et cetera. And you could do all these analyses with parts, et cetera. But when states, including ours, started allowing people to sit for the exam before finishing their current degree program, so, when they did, it sort of blurred the lines between those sitting with an undergraduate and those sitting with a master's. And so I know this firsthand because I always had to write an annual report at Rhodes about how our students did on the CPA exam. And for example, I taught the graduate auditing. I taught the undergraduate and the graduate auditing. So a lot of our students, once they could sit during their master's program for the exam, would take that graduate auditing and immediately sit for the auditing part of the CPA exam. Well, guess what? Their statistics show that they have an undergraduate degree only. They don't have a graduate degree. So if you put them into that category of undergraduate degree, you're not picking up the fact that extra education may have helped. So I think there could be ways to ask the questions, and I would encourage NASBA to look at how you're defining different groups. And I'm not designing the research, so I can't tell you exactly how I would do that. But people jump to conclusions sometimes about whether a master's helps or not, and the data may not be clean. So there's that. And my soapbox that I get on every meeting where I say I also would love to see publication of the percentage of individuals who passed all 4 parts the first time. And I've expressed that recently as sort of the reverse of that. For the accounting profession, what's the chance that you will not gain entry to the profession on your first round of testing? And I think that's valid because I think that you know that for other professions. So I had to point that out to the Education Committee as well. So see, you'll be glad I'm rotating off of here because I won't go out and cause controversy. But anyway, the bottom line is we talked about research projects. And Andy, I think it'd be great if your group talked to the Education Committee chair and talked about some research projects that could be worthwhile. So that's what I have.
And I noted your comments, so as you were speaking, so I could pass it along.
Dr. Church, your comments are always very appropriate, and we appreciate them, so we are not tired of hearing those comments. It's helpful to us, the relevant educator. We don't know, we're not always aware of the things that you are, so very, very helpful, and you have been a wonderful board member, and thank you for your service. Thank you to Kevin also for wonderful service. So we're very fortunate to have had both of you on the board. Are there other NASBA committee reports? So I serve on the Enforcement Resources Committee, which Liz Wolf leads with NASBA. And we last met, I guess we had a webinar on July the 15th. Liz, I think that's the right date. Yes. And we had, I think I've mentioned this individual to you before, but Liz arranged for Mark Bringelman, who's an attorney, presented for us. And he has done work as an assistant DA, so he's done prosecution type work, and he also has done a lot of defense work. So it's very interesting to get his perspective. He represents a couple of boards, and but also serves, that's on a contract basis, but he also serves as a defense counsel in other situations. So he kind of has the perspective on both ends regarding complaints. So very informative. And then I think, Liz, I have this date right. We also have an in-person meeting August the 11th. So that's coming up very soon here in Nashville. So looking forward to that.
Mr. Chairman, I'd just like to add that some of the board members here might not realize, but Liz was our attorney at one time here and very familiar with this room, and we're excited to have her back over here. Even though we've gotten some great attorneys now, we sure do miss your smiling face and appreciate all that you've done for the Tennessee Board. It's exciting to see you back in here. Thank you.
Thank you, Andy. Okay, do we have any updates from AICPA committees?
I'll just quickly say I went to my last peak meeting. Yay. It was that was unbelievable to be a part of. If you have not sat in on an open meeting, you can actually go out and register and sit in, and you can get CPE credit on it. And it is fascinating to see as they go through some of the different task force that are there and the changes that they're bringing to peak. I know alternative practice structures, we talked about it at the last meeting, and probably August 6th and 8th, they have open and closed meetings, and then they'll have another one in November, and I expect that we're going to see possibly some announcements in that area, really to talk about possibly an exposure draft. They're trying to get that out pretty quick with everything going on. We had an international tax service, non-attest services, and you're going to see probably an exposure draft come out on it. I think that we actually were seeking approval, and I think there was a problem there, and it was moved forward. Simultaneous employment. I think since I was on peak the entire 3 years, we talked about simultaneous employment, and we're very close to getting an exposure draft in that area. And one of the more interesting things is that they've actually drafted non-authoritative questions and answers dealing with digital assets. And I know that we're starting to see those creep up on balance sheets a lot more. And so there's some interesting things in that area. And then we got a lot of ISBA and other updates. But I encourage you, if you've never been to a PINK meeting before, please do that, because it's fascinating to sit in and kind of hear how Peak is going out and looking at independence issues. And so I know we just got finished with blockchain, And one of our issues with blockchain was, are you independent if you go to the cloud and independently pull down as the auditor the financial statements from blockchain? And so that question is coming up. What they kind of brought to us is once each block is written with an entry, it can never be changed, and then they build on each other. So you got Bitcoin, you got the blockchain digital kind of financials or digital transactions that can be built into a financial statement. And then from there, how some of the big four I've already been seeing this. I don't know if you've seen any. To me, it was fascinating. They gave us a complete update on it, and then we really got into it. And so I think you're going to see a lot of information coming out on that side.
Thanks, Andy. Did you have a comment, Pam? Sorry, okay. Any other comments or questions regarding committees? Okay, let's take a break and maybe 15 minutes. Let's reconvene at 10:10, please. Thank you. I just gave you the other one because it's a bigger font.
Sarah Hardy, who is with the UHY office in Franklin, is our current peer review committee chair. And then we have the peer review committee, which is consisted of 13 members from across the state who meet specified training and experience requirements in order to serve on that committee. Moving on to enrolled firm counts, there's a chart on slide number 4 that gives you an overview of the current enrollment information. Currently, there are 446 enrolled firms in the program, and you can see there has been a decline of an average of about 6% per year in enrollments. This is due to a variety of factors. Most commonly, we see that enrollments are declining because firms are merging, there are firm partners retiring, there are many firms who choose to no longer perform services subject to peer review and therefore are not required to be enrolled. This decline is not something that's unique to Tennessee. Administering entities across the country are seeing similar trends. However, we do see firms continuing to enroll in the program, and this information is reflective of the net decrease, so it's including firms who are newly enrolled. And I should also note that firms that perform engagements subject to PCAOB standards have peer reviews administered by the National Peer Review Committee, which is run by AICPA administrative staff. So those firms are not included in our enrollment count. The next slide gives you a very brief high-level overview of the peer review process. So kind of starting there on the left, the process begins with a firm selecting a peer reviewer and scheduling their review. The scheduling process is monitored by TSCPA as an administering entity and must be approved by TSCPA. What we're looking for there is to make sure that the peer reviewer meets all of the qualifications required by AICPA program standards. Therefore, that means they're enrolled, they're associated with a firm that's enrolled in peer review, that's had a peer review done in the last 3 years, and has a past report. So the peer reviewer is meeting the same requirements as the reviewed firm. The peer reviewer must also take annual training to make sure that they're updated on peer review program standards. So once we've checked that, the peer review takes place. At the end of the review, the firm submits documents to TSCPA for administrative review. That then goes on to technical review process, which I mentioned Art is our primary technical reviewer. Following his acceptance, it goes to the peer review committee, which is comprised of members who also meet training requirements and are working at firms enrolled in peer review. Peer reviews generally must be accepted within either 60 or 120 days. And to briefly recap that, 60-day acceptance windows apply to engagement peer reviews that are fairly clean. And then 120-day rules apply to system reviews or engagement reviews that may have issues associated with them. Once the committee reviews a peer review, they can make the decision to either accept the review as presented. They have the option to send it back for changes if they have questions or are unable to accept the review based on the information they have, or they can accept it and assign corrective actions, which I'll talk a little bit more about later in the presentation. Backing up a little bit to peer review due dates, firms must undergo a peer review once every 3 years if they're enrolled. Generally speaking, the review should cover a 1-year period, and they should maintain that same peer review period going forward. Sometimes firms do have the need to request changes to their due date or their peer review year. When that need arises, firms must request in writing from TSCPA, must be approved by us, and they have to include their reason for the request. I should also note that requests must be provided to TSCPA prior to the peer review due date. Additionally, firms should have their review scheduled with an approved peer reviewer before making the request. Several reasons may come up for firms that would require them to need a peer review year-end change or a due date change. I've included a few examples on slide number 7. Some of those examples include things like firm structure changes, mergers, dissolutions. From time to time, there may be a major engagement that falls outside of the peer review year, so things need to be adjusted to include that, or maybe the major engagement isn't finished by the peer review due date, so more time is needed. Other instances may include absence or loss of key individuals within the firm, but all requests, again, must go before TSCPA for approval, and they are approved by our CPA on staff and our committee chair, and always considered on a case-by-case basis. The committee does have a policy that's established that they follow when considering these requests. All right, moving on into some statistical information. Slide number 8 shows engagement reviews accepted for a 12-month period ended June 30th. So during that time period, TSCPA accepted 85 engagement reviews. And just to give you a brief overview of what that means, an engagement review is issued for is required for firms that issue reports under SARS. These reviews generally evaluate whether the engagements submitted for review are performed in conformity with professional standards. So to look at that information, we had 85% of those reviews accepted with a pass report, 10% had a pass with deficiencies, and 5% ended in a fail report. I pulled statistics from the AICPA reflective of engagement reviews accepted during a 12-month period for all administrating entities, and found that the statistics were very similar, very much in line with what we're seeing in Tennessee. Moving on to system reviews, which look at the firm's full system of quality control and evaluate that. Firms, generally speaking, that perform audit work or SOC engagements are subject to system review. We had 51 system reviews accepted during the 12-month period with an 84% pass rate, 6% pass with deficiencies, and a 10% fail rate. These report ratings were in line with what we saw at the national level as well. The next slide summarizes corrective actions. To give you a brief overview of what corrective actions are, the committee for non-pass reports, so pass with deficiency or fail, has the option to issue corrective actions to help the firm remediate the issues identified during the peer review. There are specific standards that prescribe the actions that may be issued for a firm in this instance, but the committee takes each situation and designs a set of corrective actions that are responsive to the issues identified during the peer review. So most commonly, the committee will issue, I say most commonly, but I should say most commonly during this 12-month period, the committee issued CPE, so submitting proof of CPE, and again, that's designed to remediate whatever the issue was during the peer review. So it's not just general CPE, it may be related to audit or financial reporting or whatever specifically is needed to help the firm remediate. Additionally, the next most common action issued was a pre or post issuance review of an engagement. So it may be that the firm requires an outside party that the committee requires an outside party acceptable to the committee to review the firm's next whatever engagement that they may have had trouble with during the peer review. So it could be specific to their next review engagement or audit engagement and so forth. The next couple of items mention that quality control centers, requiring a firm to join those, that is occasionally issued. And then several other types are sometimes issued. Less commonly, they may ask for a copy of the firm's monitoring report or quality control documentation. In some instances, I should say that multiple corrective actions may be issued on the same peer review. So it could be that CPE is issued along with a pre-issuance review and requirement to join Quality Control Center. Once the firm completes the corrective actions, those do come back to our technical reviewer or to the committee to review and make sure that they were performed in accordance with standards. In some occasions, if they were not, then the committee has the option to assign an additional set of corrective actions. I'll stop there and ask if there are any questions before I go into the firm non-cooperation process. Okay.
Katie, I have a question.
Sure.
How are we doing with respect to the pool of peer reviewers? I know at one time that was a concern. Is that still a concern, or we?
From what I understand, it is. Now, usually the AICPA will report on that from a national level during this peer review conference that's happening today, so I'll probably know more about that after today. We have seen a slight decline in Tennessee in our number of peer reviewers, and I think that is on trend with other states, but the AICPA has several initiatives which TSCPA is supportive of to try to recruit more peer reviewers into that pool.
So does that cause a problem with scheduling, or there people can't really get into the program because of that, or?
It has not, to my knowledge. Now, firms do have the option, if they're unable to find a Tennessee peer reviewer, there's not a requirement that they use someone in the state, so they have the option to utilize qualified reviewers in another state. They have access to a database of qualified peer reviewers from around the country. So we often, if we receive calls from firms who are having trouble scheduling, we'll refer them to that resource. But it should not be, the shortage or the decrease in reviewers is not significant enough that it would prevent firms from being able to schedule.
Katie,
Sure.
quickly, is the society or the AICPA at all concerned with the lower enrollment firm counts over the past 10 years? It's been fairly consistent, and I know we've been consistent with other states, as you had mentioned. However, identifying, why fewer firms are enrolled, is it because they are just more enlightened that maybe they don't need to be in that area of practice and voluntarily dropping their audit practice and dropping enrollment? Does that seem to be the major reason? And is there any other concern expressed by it? Do you think the lack of enrollment means anything beyond that we know of?
I would not say there's any concern at this
Okay.
point. We have data that supports why each of those firms unenrolls from the program, or whether, it may be due to non-cooperation. That's not a substantial part of that decline. But we also have information on, if it's a firm merger or a firm sale. That's a really common reason. When SARS 21 came out several years ago, that caused a very large decline because many firms opted to just do preparations of financial statements and therefore were not required to be enrolled in peer review. So that created some of that decline as well.
And then one more question, Katie. I appreciate the presentation this morning very much, but we've had recently adopted standards with respect to firm systems reviews. And just to drill down a little bit on the earlier questions, what are we seeing in terms of available capacity to do those types of system reviews? And is that maybe adding to concern about availability of resources?
So in order to perform a peer review of a system review, you do have to be a partner in a peer review firm. So that's slightly heightened requirement when compared to peer reviewers who only do engagement reviews. I wouldn't say that I've seen any strain on that particular pool of eligible peer reviewers that would cause concern at this point in time.
Thank you.
Sure.
Katie, I echo thanks for your presentation here.
Sure.
At one time, it seemed like regarding administration of peer reviews, some states were taking on administration of other states. Is that still a movement that's happening? Is that sort of stalled, or where do you see that going in the future?
I haven't seen quite as much movement over the last couple of years. There was quite a bit of movement going back over the last 10 years of firms or of state societies joining together and creating groups of states to administer the peer review program. I don't have the exact number of administering entities right now. I would say it's around 20 to 25 or so. So there have been quite a few states that are joining together, but it seems to have decreased in number over the last year or two. So I have some more information on specific to the non-cooperation process for the peer review program. Before we get into that, I'll mention that anytime there is non-cooperation with a firm in the program, the TSCPA follows very prescribed specific procedures in the program standards. All of these procedures are very programmatic in nature, and each firm is given adequate due process to understand the noncompliance issue and have the opportunity to resolve that. So kind of getting into that a little bit, there is a slide that talks about drops and terminations. So a drop from the peer review program indicates the firm's failure to cooperate prior to the commencement of a peer review. So it's a timing, it's defined by timing, a drop. So that may be failure to schedule a peer review or failure to pay administrative fees. Those are a couple of examples. Prior to the firm's enrollment being dropped, they receive notification about whatever the overdue item is. They're notified by email and by certified mail and have the opportunity to resolve that issue. If they don't resolve the issue and they're dropped, we communicate that to the Board of Accountancy. That information is also available through the FSBA portal, but we communicate that to Jen and to Karen in real time when that happens. If a firm needs to re-enroll in the program, they're required to resolve whatever the issue was in order to have their enrollment reinstated. And generally, when that happens, they're required to undergo a peer review within 90 days. The other way a firm may exit the program is through a termination. And again, this is defined by timing, but this is failure to cooperate after the commencement of a peer review has happened. This process is a little bit more involved, but it may result from failure to complete a review or a corrective action. Maybe midway through the peer review, the firm has stopped responding to the peer reviewer. It may also generate from consecutive non-pass reports or failure to improve after consecutive corrective actions on the same peer review. Anytime something comes up that could result in a termination, it must first go to the peer review committee to review. If the committee determines that the firm has not been cooperative, then they're referred to the AICPA. Their staff then investigates the issue. If they determine the firm's not being cooperative and the firm does not take the opportunity that they're given at that point to correct the issue, then the firm is referred to the AICPA peer review board, who may then vote to terminate the firm. But the firm is eligible to participate in that hearing. And once the hearing happens, if they are terminated, they have a 30-day time period to appeal that. Terminations are always made public. However, we do still communicate those in real time when they happen to Jen and to Karen. But they're available on the AICPA website as well following that 30-day appeal period that the firm has. I have a slide included that shows step-by-step the firm termination process. So it begins with outreach to the firm. TSCPA is required to use multiple forms of outreach. So in other words, if we email the firm and they're non-responsive, we give them a call. They also receive certified mail so that we know they're well aware of the violation. Their cooperation is evaluated by the committee and AICPA staff, as I mentioned. AICPA staff will also perform outreach, and then they go to the hearing panel and the 30-day appeal period, as I mentioned. After a termination, the firm is still eligible to reinstate their enrollment. To do that, they must, again, resolve the issue that led to that termination or to that drop. In some situations, the firm must reinstate through the AICPA peer review board. Those situations would include reinstatement after termination from consecutive non-pass reports or failure to improve after consecutive corrective actions on the same peer review. Looking at our drop in termination statistics from 2024, you can see there were 19 firms dropped from the peer review program in Tennessee. 13 of those failed to schedule a peer review. 6 of those failed to pay administrative fees. And then 2 firms were terminated for failure to complete a peer review or corrective actions on a peer review. And just to recap the transparency around enrollment, TUSCPA notifies the board staff when both terminations and drops occur, and the board staff may also access enrollment reports at any time through the facilitated state board access secure portal on the AICPA website. I will move on quickly into oversight in the peer review program. So there are several types of oversight. I'll start with AICPA's oversight of TSCPA. So TSCPA is required to adhere to multiple benchmarks in order to administer the peer review program. If TSCPA, for whatever reason, were not adhering to those benchmarks, then we would be in jeopardy of no longer being eligible to serve as administrators. So a few ways that the AICPA monitors TSCPA. One is through report acceptance body observations. Generally speaking, they'll sit in on about 3 of our report acceptance body or RAB meetings per year. And they're just listening to make sure that we're adhering to professional standards. They're making sure all of our peer review committee members meet the qualifications, that the technical reviewer process is following standards, and so on. We report on certain benchmarks to the AICPA 3 times a year to measure our compliance with set standards. And then every 2 to 3 years, the AICPA will send a member of their staff or their oversight task force to our office to review our policies, our procedures, and our overall adherence to guidance. So we do have a visit with them scheduled for this September. And after that oversight visit, they'll issue a report that will be published on our website, so that's publicly available. The final slide talks about our other oversight procedures, which are enhanced oversight. That is actually run and fully executed by the AICPA, but they will typically use a risk-based approach. Most often we see they're selecting peer reviews that deal with high-risk engagements to pull in a subject matter expert to look at that peer review, either during its performance or after it's performed, to make sure that the peer review report was issued in accordance with professional standards. And then TSCPA also maintains an oversight program that is risk-based, and we are required to oversight 2% of peer reviews performed in a year. So we select those firms or peer reviewers to be oversighted and then engage a qualified reviewer to review that peer review either during or after it's performed to make sure that it was issued within professional standards. With that, that's my final slide. I'm happy to take more questions if you have them.
Katie, I got a comment based on the reduction in the size of firms. I mean, I really am concerned as a board member that we have a lot of people who are performing a test work that are over 60 that really do a good job in our local counties. And I'm concerned that, you know, we may not have people to fill those seats as they start retiring. Has the TSCPA looked at that in any way as to the age of the firms?
The firms who are performing the
Or the
test work.
employees, a lot of them are one or two men shops or ladies.
We do, TSCPA keeps a constant eye on the numbers of CPAs in Tennessee. We're well aware of the kind of the cliff of baby boomers reaching retirement age, and have put a lot of resources into trying to strengthen the pipeline. Now, that doesn't directly solve the problem that you're referencing, Andy, doesn't directly answer your question, but we are putting a lot of resource into enhancing the pipeline.
Well, very much appreciated, because I think that we're going to have a shortage. Because a couple of the industrial development boards, for example, they have to have their own audit. People were coming to me and saying that, hey, we can't find anybody, the firms, you know, out of Knoxville, saying they're not taking any more clients because they have too many already at that time at 6:30. And then they were very concerned about what's going to happen when their 75-year-old
Right.
firm, who's a one-man shop, retires. Because I think he was doing 6 or 7
Right.
different counties. And so it really seems to be a problem that's brewing, and anything the TSCPA can do to help in that area would be greatly appreciated.
No, I think that's a great question and a valid concern. We do receive calls from the public periodically looking for peer reviewers, or not peer reviewers, looking for CPAs based on the situation you described, Andy. And we have a Find a CPA public resource tool that we will often refer members of the public to if they need a CPA that performs a certain type of work or practices in a specific industry. We can try to assist them by pointing them in that direction.
The other question I've got is just is to go back to alternative practice structures and private equity. It would really be great. I know you're very highly involved in the peer review program, but to emphasize the importance of looking at those agreements, looking at the management documents of how they define their independence and
Sure.
getting input, and doing a little bit extra in that area when you look at those services. Because a lot of things that are being talked to me about are very much concerned. You know, private equity is coming into these firms and buying these firms, and then they're splitting the test work off, and they're not in it except to make a profit. And just to ensure that there's not a lot of corners being cut, make sure that we don't have any risk, you know, to the general public, because that's what we're worried about, is public protection. But, you know, emphasizing the documentation and adherence to the standards above and beyond, because it really is a high-risk area for our profession, and also for the people of Tennessee that could find themselves in a situation where maybe a private equity split, they're more concerned about profit than they are service, and maybe start cutting some corners. And the other thing is just as they're doing that, just to take a look at the websites. I mean, it's hard for me to understand how you can have the same website for both services. It's hard for me to understand how you can walk in the same door and one side's a test and the other side's tax, and you're sitting in a meeting with the attest side and they're saying, let me go get my partner over here on tax and he can show you what you need to do. And it seems like we're crossing the line a little bit in not all cases. I mean, there's a lot of good ones out there, but it's the bad ones that define how we have to, kind of look at our profession. And so anything that you can do as head of that program to kind of emphasize that area would be fantastic, just to make sure our public is protected in Tennessee.
I understand your concern, certainly. I will say that the AICPA started a webinar series last week on alternate practice structures, and during that webinar, Sue Coffey indicated that peer review was one of the guardrails they have to preserve quality in those alternate practice structures. She did mention that it may be further enhanced to address those alternate structures. So TSCPA is certainly staying informed and staying part of that conversation. I suspect that we'll know a little bit more after the peer review conference wraps up this week. So we'll be happy to inform the board of what we learn at the next meeting if you would like.
Fantastic. Thank you, Katie. Mr. Chairman, I got one more question just for Jen. Just kind of will you remind me how the board is monitoring our peer review of the program that the TSCPA is doing for us?
Yes, so there are a couple of touch points that we have with the peer review process. As Katie mentioned, board staff, we have access to a platform called FSBA. It's a subset of the AICPA's PRIMA system, which is where peer review is maintained and administered. Like Katie mentioned, when firms are dropped or terminated from the program, we are directly notified by the TSCPA, and we also follow up with those firms via an email. If we don't get response via email, we send certified mail just to say, hey, we're aware. Are you still doing a test work? Let's help you get back into compliance. In an egregious instance where someone's just not responsive to us or the peer review program, we would open a complaint and take that through the complaint process. You would hear about it. In addition, when firms apply for a firm permit and at renewal every year, we are asking the question, are you providing a test services? Do you anticipate providing a test services? And especially at renewal, we are checking in FSBA to understand where they are in the peer review process and ensure that they are where they should be in the cycle. So that's how we as board staff monitor peer review compliance.
Well, I appreciate that and appreciate what you're doing and actually how up to speed you're coming with everything here at the board, and thank you for all you do. One thing I didn't say was that when we got to the board meeting, they put up a picture of Jen up there at NASBU for the whole board to see. I was like, that's our executive director right there, baby. She's a rock star in Tennessee, so we appreciate what you do.
Other comments or questions? Katie, thank you very much. You've taken your time today to be with us and to do this presentation. We're very appreciative of that. And as Andy mentioned earlier, our primary job is to protect the public. And one of the tools we use is we rely on you for the peer review. So that's very important to us, your work. So thank you for that.
Thank you, Mr. Chairman.
Our next agenda item is new business, and the first order of business under that is the election of officers for this coming year. And before we go through that, I have not been your chair through this process. Last year when I was elected, I was not presiding at this meeting. Chairman Bonner was at that time. And it's Jen's first rodeo through this process also. So Jen, I don't know if you have any comments before we start this process or not.
I don't have any comments.
Okay, thank you. So typically, Jen and I have both reviewed some of what we've done in the past, and we have some former chairmen here, so you all help us through the process. But our first order of business will be to elect a chairman for this forthcoming year. So,
Mr. Chairman, I would like to nominate you to be chair for another year. I know that your first year has been very challenging and that you had to immediately go find an executive director. That happened in September. And you've done an excellent job in doing that with the department's help. And I just think that we could use your leadership for one more year, if you would accept that.
Thank you, Andy. I would be delighted to do so, but with that nomination on the floor, I would like to ask our vice chair to maybe preside over this part of the election process.
Be glad to. So this is my first rodeo at this, so I'll rely on the previous chairs and a sitting board chair also. So Chairman Gilbert has been nominated for an additional term of a year as chair. Are there any other nominations? Hearing none, I declare the nominations closed. And I guess my only question is, do we do just an aye, nay vote at this point, or do we do any kind of roll call?
I think a voice vote will be fine.
Okay. So all in favor of electing Chairman Gilbert for an additional term as chair of the board, please say aye.
Aye.
Any nays? Congratulations.
Thank you, John. And Reed, thank you. And I'm sure Maggie was involved in this process also, but I know you helped with the reappointment for me for another term, so thank you for that work. And I think we have a great board. Thank you for the honor of serving as your chair. I've certainly tried to observe the two previous chairs to see the good work. I've seen a lot of good work that you all have done, and thank you for mentoring me, or that you weren't doing it intentionally for me, but certainly your work has helped me in the process. So thank you very much. And so I suppose our next order of business is the election of a vice chair. And I would open the floor for nominations.
Mr. Chairman, I would recommend or make a motion that we re-elect the current vice chair, who has only served one term, and I think traditionally 2 consecutive years are appropriate for officers who have done a masterful job, and I think our chair, vice chair has done a masterful job at that, staying out of your way and allowing you to lead this board effectively. So I would nominate Mr. Griesbeck for that.
Thank you. Are there other nominations? Okay. I think we need a second for that. Second. Those in favor say aye. Aye. Those opposed, nay. Congratulations, Mr. Griesbeck. Not only has John done a really remarkable job in this role, and I say that in all seriousness, but I know the past quarter or so, we worked on the discipline matrix and the other items that he presented today. So he has had a full plate at least for the last quarter that I know of. So thank you, John. Congratulations. At this point, we need to elect a secretary for this coming year. Our current secretary has done remarkable work, but I suppose the term has pretty much ended. So
That's what they say.
that's what they say. So I would entertain a motion for nominee or nominees for secretary.
Mr. Chairman, if Mr. Vance has an interest in serving, I would nominate Rob Vance.
If there are no other candidates, I would accept. Thank you. But if someone else is very interested, please speak up.
We have a second. Do we have other, Andy, I think your mic was on. Were you going to make a comment or no? Okay. Okay. Those in favor of electing Mr. Vance as secretary, say aye. Aye. Those opposed, nay. Congratulations, Rob.
Thank you. I get to sign the CPA certificate now?
You do. Yes, sir. Yes, sir.
That has got to be one of the biggest honors, because I still look at my CPA certificate every day, and I thought, golly, those two people that signed it, so that will be an honor. That will definitely be an honor. Right. Do it?
Yeah.
You know, I understand that they do use something like that these days, so it's not the hand signature anymore, so, but thank you.
Congratulations, Rob. We will then begin the process of forming the committees, and Jen, you may have a comment or two about this process.
Yes, if you're interested in being on a specific committee or particularly chairing a committee next year, please let me know. Greg and I will work on those in the next month or so. Yes, that's all I have to say.
Thank you. At this point, we'll turn the program over to our Assistant Commissioner of Department of Commerce and Insurance, Reed Witcher. Reed, welcome again, and we look forward to your comments.
Thank you, Mr. Chairman, and I appreciate the board reserving some time for a departmental update this morning. That should come as a surprise to no members of the committee before me. But Jen mentioned earlier in one of her updates that the board is currently projected to be around $70,000 in the red for fiscal year 25. And those of you who have been on the board for some time know that this is the third consecutive year that the board has operated in the red and at a growing rate. And of course, that the board has been interested in finding some solution to that growing deficit. So with that background in mind, the department plans to begin the assignment of work of some small regulatory programs to Jen and her team beginning in August. This will create some operational efficiencies for the department, certainly, but I see first and foremost as a benefit to this board, as a way to get back into a balanced budget without having to raise fees or cut services to your licensees, which I think is a great thing and certainly aligns with Governor Lee's vision for how these boards are administered. I have some stats in front of me that I want to share with you. But I first want to just brag on Jen and her team. You all know that we're very proud of the staff that supports this board. And they are among the most efficient of the 8 teams that we have in the department that supports licensees. Jen mentioned in her comments earlier that in the previous quarter, the board, I think, averaged, you said, north of 7 days average licensing time. That's a metric we measure very closely for the department. But over the previous fiscal year, the accountancy team averaged 5.9 days for license processing time against a divisional average goal of 14 days. So this is a remarkably efficient team. They are also growing in their efficiency. 2 fiscal years ago, they were averaging 8.4 days to process a license. In the previous year, they were averaging just over 7 days to process a license. We're proud of that work. That's great. And that directly supports the licensees that you all do such a great job representing. So with that in mind, we believe that this team has the bandwidth to support some additional small regulatory program work. Specifically, what we are looking at doing is dedicating not more than 25% of Jen's time to these additional programs, not more than 10% of Karen's time to these programs, and not more than 25% of Laura Pecunius's time. That will result in a savings of a little over $60,000 annually for this board, which is obviously significant when you review your recent financials in terms of getting back on track for operating in the black. In terms of workload, these 3 programs have a combined 700 licensees in total as compared to the 14,000 total that this board oversees. We have a lot of data. You all know that. These 3 programs combined had 122 calls and emails to our customer service center last year. They had 40 initial applications, new folks seeking licensure in the previous fiscal year. So again, relative to the work of the accountancy board, a very small, a light lift for this team. One of these programs does have a 5-member board that meets quarterly. Jen will be tasked with administering those board meetings in the manner that she does these board meetings. I mentioned to some of you when we spoke, those board meetings tend to last less than an hour. It's been 6 years since that board had a meeting that lasted more than an hour. I do want to point out that these 3 programs are supported by a different legal team, so this won't eat into any of Lee's time or any of the other folks that support this program. So that's a little bit of information about the lift. I also do want to make sure that this board knows and has confidence in the department's position of the value in Jen and her team's participation in work with NASBA and AICPA. That is to the benefit of this board and to the benefit of your licensees. Certainly in the current climate that we're in, where there's been such tremendous change. I know that Jen, as a licensee of this board, also takes that responsibility very seriously. But I do want to point out that it will be a continued expectation, in addition to the fact that minimally it's expected that Jen is spending 75% of her time supporting this board and your licensees, that Jen is attending regional and national meetings, that she's participating in monthly calls with her peer executive directors, that she participates in NASBA surveys that they send out seeking input from boards. I know that's very important work that there will be an expectation that Jen continues. And I think a great level of accountability, because Jen so thoroughly updates this board on the work that she does. I don't know if Jen has mentioned today or yesterday that Jen also, under the advisement of wise counsel, Wendy Garvin, has requested to be a member of multiple NASBA committees next year as they do their committee formation process. And she, of course, has the department's full support in that work. So in conclusion, we're confident that this is workload that Jen and her team will be able to successfully administer without any detraction from this board or from your licensees, but wanted to provide that update to you and give this board an opportunity to ask any questions before we proceed with that plan, excuse me.
Reed, thank you for the presentation, and it makes a lot of sense to me, particularly from a financial standpoint. So one question that I thought of, and you and I had a nice conversation prior to this meeting, but I would like for us to maybe just monitor or have some way to monitor, I guess is the right word, scope creep. So decrease in workload or in availability for the Board of Accountancy and increase for the other. And I know with you in your current position that would not be an issue, but any advice on the future, and you may not have an answer to that now because that question just recently popped in my head, but if we could just watch that so that we do have a director who has the availability to serve on the NASBA committees and do the kinds of things that we ask.
Sure. 2 authorities that this board has that are somewhat unusual for regulatory boards attached to the department are your budget authority and the authority that you all have to hire an executive director. I think that is a check that you have on the system to avoid that sort of creep.
I'd just like to echo Chairman's comments and thank you for the analysis and great effort y'all went through to do this, and even more importantly, the support that the department is offering to our board and to Jen and the staff. It's very much appreciated.
Reed, I had a couple of questions, and first one was that I know when we talked, you talked about a savings, but the net savings for the state of Tennessee, would there be any net savings there, or are we just transferring some of our expenses over to the other board at this time?
So, so yes, I would say the latter, but also for additional context, a new board was created during this legislative session that the department will administer. We will begin licensing bail bondsmen on January 1st, which is a significant lift for our division. So with that, there's work to be distributed, right? So, in fact, our balance sheet will will grow a bit as a result of those legislative changes. But no, in this instance, we're seeing a shift, and of course, we're mindful of wanting to. We're not creating a financial burden to those programs as they move from being administered by one executive director to another.
One of my reservations is that we just changed our pathway here in Tennessee, and I don't think we've seen the full effect of the impact it's going to have on our staff. And I'm very concerned that once we see that impact, that they may be overwhelmed with the volume that's occurring, because we're starting to see people studying more for the exam. We're starting to see them take more parts of the exam, and if you look at just the ages of the profession, there's going to be should be this large increase in numbers getting into the profession, and that's what our whole hopes are as we change our pathways. One of the things that I'm concerned about is once we do this, as a board, but we have the ability to undo it if we see that it is affecting us. And I know me and you had talked a little bit in that area, and you kind of assured me on the phone that we would be able to undo this if we found out it's a burden.
Certainly. This process is very much a partnership. I think that it's a partnership that we have had to exercise, obviously, in the last year as we work to fill the position. But yes, this is, we have the ability in an ongoing way to make adjustments as needed. I will say, I hope that we are in the position that you've outlined where this board is figuring out how to timely process licenses in an environment where we have a significant increase in volume. That'd be great news for the profession and to address some of the issues you mentioned during the previous presentation. But I'll also add to that I think that as the board reviews those sorts of scenarios, we have a customer service oriented viewpoint from the department's perspective of supporting customers. It's my goal, and I talk to my team about this a lot, that I want us to exceed expectations for what someone has when they are interacting with the government, right? All that to say, the licensing time of this team is less than half of what their divisional goal is. So they are working ahead in such a way that they have some flexibility for increased workload, both from this program and others. And I still think that they would be meeting their customers' expectations in a really meaningful way.
So I'm a country boy. So in full circle, if this board decides that we need her back and we're willing to, as a profession, increase our fees across the state to avoid any losses within our board, that we could do that as a board. Is that correct?
As a Northeast Tennessean, the quick way to say it is, this board lets us know that there's a problem and we'll address the problem. Yes.
That's my biggest concern, is that, we're sitting on a $1.5 million fund balance, so that really the losses we've had are not much. In fact, when I was chair, we actually talked about increasing the fees to avoid any losses. And so to ensure that we didn't get to this point, now it seems like that our losses are being used against us to kind of merge that out. And I really want to make sure that if we go down this road, that we can back up and bring it back to where we just have our ED being 100% on the board, if that's what we need. Now, if we have other staff that's not as busy, I'm all for it, but I really think it's important to have our ED 100% focused on the accounting board. And so I'll leave this those comments, Mr. Chairman.
Thank you, Andy. Other comments?
Mr. Chairman, I guess I would, yeah, I have no objection to what has been proposed. I just would ask that the meeting minutes reflect this conversation, and we all know that there's going to be a gubernatorial election next year and a change in administration one way or the other. And so those who occupy Reed's chair in 2 years' time, just to make sure that this this sort of agreement that we have is there for anyone who comes into these roles in 2 years' time, and to the extent that, as Member Bonner says, if we have reason to renegotiate or need to renegotiate, it's there.
Great. Great point. Other comments? I want to echo something that you mentioned, Reed. I think we have had a great partnership, and you and I met, I guess, a little over a year ago, and I think we've had open conversations and really good communication between us and certainly between you and the board, and we're very appreciative of that. One of the things you really impressed me with was when Wendy resigned, you told me we would have a new executive director within a very few number of days. I can't remember if it was 30 or 60, and we did. And your team went to work and helped us with that, and I was traveling at that time, and you were very cooperative, and we asked Brad to step in and help with the interview process. And so it has been a partnership that I think has worked very well, so thank you for that.
I appreciate that, Mr. Chairman. It is my job and our job to make your all's jobs easy. So that's our goal.
I don't believe there's any formal action that the board needs to take regarding this matter. So
That's correct, yeah.
Anything else that you have for us?
No, I appreciate each of your time individually as we've considered the repercussions of this, and thanks for the feedback today as well. This is helpful to the department. Thank you.
Thank you again. I mentioned this earlier, but I do want us to take just a moment and recognize Andy Bonner. Andy was recently presented with the TSCPA's 2025 Lifetime Achievement Award, and I'll just read some of the information from the TSCPA. The TSCPA Awards Program recognizes the many ways that individuals contribute significant time, energy, and intellect to developing the accounting profession and fostering its success. The Lifetime Achievement Award is given in recognition of a TSCPA member who has exhibited leadership, made significant contributions to the profession, and had an outstanding record of service to the society and the local community. So Andy, obviously the TSCPA is very proud of you. We are too, so congratulations. Okay, we will move to the public comment section of the agenda.
Mr. Chairman?
Yes, sir.
I'm
Sorry.
I probably should have
sorry.
mentioned this at the beginning of the meeting. I do have an additional item for new business.
Yes, sir.
This will only take about maybe 5 minutes. When Reed and I spoke during our conversation about cost cutting, I, of course, brought up the idea, or I guess I said, we spend a lot of time and effort on enforcement with the Contractors License Board, as we all know. In fact, at the May meeting, we had 8 cases of contractor license enforcement, and I believe 5 of them were first-timers, which whether they knew or not about the law was, I guess, another issue. But so when Reed and I talked, he actually proposed an idea, which I think is it's certainly worth us considering. I don't think it's a vote or anything like that. It's just something for us to bring up at perhaps the next meeting. And then Reed then asked Lee to write an excellent memo about this, and I'll jump straight to the facts, and then I'll tell you what I guess the authority is for this real quick. A substantial number of the Accountancy Board's disciplinary cases originate with the Contractors Board. Typically, in such cases, a person who we will call the preparer has prepared an attest report for a contractor, and the contractor has submitted the attest report to the contractor's board. Since the preparer's work constitutes an attest service, the preparer must meet 3 requirements, as we all know. Must be a CPA with the firm permit, and he must be enrolled in the peer review process. There's some code sites here. Due to these requirements, the contractor's board investigates the credentials of some or all preparers of these attest reports. As we all know, the contractor's board determines that the preparer lacks one or more of these requirements. That board refers the preparer to the accountancy board for further investigation and possible discipline. So the question is presented, and Lee has presented this in an excellent legal type format. Under the Tennessee Accountancy Act, may the Tennessee State Board of Accountancy delegate authority to its staff to issue agreed citations directly to respondents who have prepared unlawful financial statements for contractors overseen by the Tennessee Board for Licensing Contractors? The brief answer is yes. The Act broadly empowers the Accountancy Board to appoint and execute an executive director and retain staff to be responsible for the daily operations of the board, including but not limited to other matters that implementation of board policies and procedures and any other matters delegated by the board. So all of this is really here to lighten the load of the board and I think supposedly lessen our legal fees and investigative fees. And I don't have a dollar amount for you, and Reed doesn't either, I believe, or Lee. But this should lessen the load, enforcement committee and costs. And that's sort of the bottom line, is that this is supposed to reduce our costs. So here's the proposal. Since the facts of the cases follow a recognized pattern, meaning the violations, and the violations are typically proven with undisputed licensing records, it has been suggested that the Accountancy Board may streamline the disciplinary process in these cases with an agreed citation order. Under the system, the accountancy staff would review new referrals from the Contractors Board and, if appropriate, simply notate all violations on a form and entitled, quote-unquote, citation or a notice of violation, they may call that, such as like a patrolman issuing a speeding ticket to someone. If the preparer is willing to settle the matter, and obviously that's the key right there, and that's where the costs stop, he may simply pay the citation and the matter would be resolved without the expenses and delay of an investigation and quarterly legal report. If the preparer is unwilling to settle, then of course the board would review the matter in its quarterly legal report like we do every quarter. To incentivize preparers to settle, the citation would require a civil penalty less than $1,000 maximum provided by the law. Possibly civil penalties could be for no certificate, $750, for no firm permit, $750, and for no enrollment in peer review, $750. Now, I'm assuming that that's perhaps lower than our penalty might be, but it would be certainly offset with hopefully more of a legal expense savings. It should be noted that the system may only be appropriate for first-time offenders who are sometimes unaware that they have violated attest requirements by preparing a contractor's financial statement. You know, I know there's no excuse for that. They should be prepared. As I mentioned yesterday, it's in the code. You're not even supposed to do that type of work. Repeat offenders, on the other hand, are more likely to be aware that their conduct violates the act, so additional discipline should be considered on a case-by-case basis by the staff and the board. So this is just a proposal for us to just lighten the load, such as under the proposed discipline last May, 5 of those cases, I suppose, would be under the consent agenda, or they wouldn't even come before us at all. They would have signed off on the form, paid the fine. Maybe we get a report that happened, and then we don't have to deal with it. That's just simply a proposal. I'm assuming that we'll bring this up again at the next meeting, and this would require a vote, I would imagine. So Reed or Lee, comments, please, on that process, what the process would be to carry this out.
I'll say briefly, we have quite a few of our boards utilize this in this exact sort of scenario, where it's sort of an indisputable, clear fact pattern, And I think it could be a help to the board, and appreciate the discussion that we've had about it over the last couple of weeks. Lee, do you want to talk about the process for adopting an agreed citation schedule?
Well, this would simply be a matter of delegation. You could vote on it. And I would point out, as you're discussing it, what is proposed is not a delegation of your legal authority. You're just simply delegating the ministerial act of going to a respondent who has violated the law and saying, here are the ways you violated the law. Are you willing to pay a civil penalty and resolve the case? So if the respondent is not willing to do that, then you have retained your legal authority, and you can then address the case at your next quarterly meeting.
It would be something like a letter of a warning or something, obviously instruction or instruction or warning and penalty, something along those lines, right?
Well, it's whatever, each case is different. That's another important point. No cases, these are not cookie cutter cases. But what you are doing is recognizing the board is seeing a pattern. A number of cases are quite similar. And in those cases, you're delegating the ministerial act of kind of doing the math and asking for a civil penalty to be paid. But, you know, if the respondent doesn't want to settle, the board can address that case any way the board sees fit.
I do want to note a couple of things. Appreciate you walking the board through this memo. The $750 per violation for these 3 violations that are typically tied together is not necessarily a recommendation to the board so much as just a starting point of thinking about how this could work. So that's not a number that, to my knowledge, we've concluded is appropriate. We're just sort of teeing that up for consideration. The other thing is, we mentioned a couple of times, these referrals from the contractor's board, you could limit the staff to only considering this for those referrals from the contractor's board. Obviously, there are other instances where this happens, that the referral is coming from a general public complainant, another CPA firm, and you can consider, the board could consider whether they want the staff to act on any instance where that's happening or merely from referrals from the contractor's board.
I would think these would be, certainly in the cases where the person claims to be unaware that this was a violation and a first timer.
Thank you, Rob and Reed. And I personally like the concept. I do think that we might need to work some on the nomenclature because we talk a lot in here about prepare, and I'm not sure that we as CPAs can really prepare financials. So I think we're really talking about an attest function, right? Compilation, review, or audit. And is that correct? I'm not an A&A expert, so so I think we might need to just clarify that and utilize the term attest function in some way. But
I would think it would just be review and compilation. I wouldn't think that if someone issues an audit and hasn't done any of this, a firm permit or peer review, I would think that wouldn't be an automatic. I would think that'd come to the board. That's, you know, it's the highest level. You know, so.
Mr. Chairman, I think this is an intriguing proposal. You know, there's still a piece of me, and recognizing the advice of our counsel at yesterday's committee meetings. I mean, we don't have jurisdiction over what the Contractors Licensing Board has jurisdiction, but there is a piece of me that wishes that in the forms that are sent out to CPAs that are going to be doing work that will be passed up to them, that they could put in 20 size font, bold font, something along the lines of, before you do this, if you don't have a firm permit, you're not enrolled in peer review, and you're not a CPA, don't even think about it. You know, that would be, you know, maybe we can head this off by preventing some of that action, and I like this after the fact. We're still after the fact, but it might save some time and effort on the part of many. So that's just an intriguing idea.
It's not mine. I'm simply the mouthpiece for it. It's Reed. Reed and Lee, thank you.
I guess the one thing I want to make sure about is that at least that if they do agree to that it is published with the penalty. That would, if they're doing that to get out of that, let's pay the citation, you don't have to go to court. Pay the citation, you don't have to be published. I mean, I would have a problem with that.
No, they would still appear in the DAR. The disciplinary action report that the department publishes each month, yes. Thank you.
Regarding our recently this morning approved revised discipline matrix, I mean, it sort of goes hand in hand with that. I'm not sure that it's sort of meting out the punishment, this penalty that's called for in there in a more efficient way, it seems like. So most of me is kind of thinking it doesn't affect that really. It's just sort of kind of runs parallel with that and helps administer. Does that make sense? And then the only other thought I would say is, do we just use the normal violation amount here? Do we offer some type of discount or reduced penalty? Part of me is like, I'm not sure why we should do that if there's been a violation, but I understand, also it may be expedient to do that if we want to get these settled and not have to go through all the motions of the staff and the board to deal with them.
And I think that's at the discretion of this board. What you feel is appropriate. I mean, if you're talking about 3 violations, that doesn't need to be a $750 discount for settling this either. If you got a $50 discount 3 times, that adds up perhaps to be a slight incentive for someone to settle. So, but ultimately, whatever those numbers and appropriate penalties are, we would defer to the board to set those.
I guess thinking a little bit longer about it, the other thing is public protection, right? So it's not about the fine, but also if we could consider in the agreement that they also reimburse the client for the services that they just performed that they weren't authorized to perform, because now that client has got to go out and pay for that service to be done. And, beyond that, I don't know if we have much more say, but if I was a customer of that firm that just handed me a report and I was counting on getting that license and now it's going to delay me from doing work, I'd say I'm coming after that person to say there's more than just the fee for the services. Now I want you to reimburse me for my lost revenue associated with my delay. So there's a huge picture here of things that can go wrong in protecting the public, because I would be outraged to think that the Tennessee board would just accept a small little fine, if you will, using that term, when in fact I need to get my services done and I want to get reimbursed as a Tennessee resident for the service that I just paid. So I hope that we would build that into the agreement, that at a minimum that they would have to give the services fees back, because now you've got somebody else going out trying to get a new test service to get a license at the board level.
Well, Mr. Bonner, you're asking a great question there, and unfortunately, I don't have an answer today, but I'm going to get one, because that is, civil penalties are spelled out in the statute. Other forms of discipline are spelled out in the statute. Whether the board has some authority to impose a reimbursement, that's a great question.
I would say, if I may, we have historically not involved ourselves in fee disputes between a client and, or complainant and a respondent. And then the other thing is, we know that it's being referred to us because the Contractors Licensing Board has already rejected the report. And so at a minimum, the client is going to have to go out and get somebody else to do, who is qualified to do the issuance of the reviewed financial statements. And then I want to think through that, Annie, but I'm not sure we want to inject ourselves in a contractual, or fee dispute between the respondent and between the contractor and their CPA, hopeful CPA, if in fact they have that status. So that kind of raises some good issues in terms of food for thought there.
Well, I know we can't do it as a board, but if this is voluntary and they're going to agree to this, I mean, I would hope that maybe we could say, hey, we also want you to reimburse the fees, even though, just to take care of that resident in Tennessee. It might be easier to, because in most of the cases that we've seen, that was the first thing that the firm considered. Now, I can't say I saw it always, but it seems like in about 3/4 of them, they as trying to get us to consider a lesser fine, they actually say, well, we gave our fees back to the customer. And so I think it's those people who made an honest mistake and the ones that are not trying to take advantage of the system. I think that they would probably be doing that anyway, but it would be great to think that we put that in there is kind of where I'm coming from. Now, the bad players will always say, no, I'm not giving it back. And we can't do anything about that. But the process, we might be better off to bring the bad players to the board in that case, because they may be willing to pay that lesser amount and say, well, I didn't even have to go to the Board of Accountancy. And maybe that will push them to say, okay, I'll get the fee back. It's just a thought.
So, Jen and Lee, sorry, shall we work on this a bit more and then maybe have further conversation or maybe a proposal for our next board meeting? Is that fair, Rob? Is that?
That's wonderful. And I'd also like an estimate really of how much time and effort and cost this might save us. I mean, that's the guise of this whole proposal, is to save time and administrative cost. I mean, I'd like to know if there's any way to estimate what that would save us. Because that was our original conversation as to why we would even consider this. And I'd like to address the idea that even if we got a lesser fee, I would think these first-time offenders, correct me if I'm wrong, they usually do show a lot of remorse, right? I mean, they're like, oh gosh, I had no idea. I mean, do they go to a quick settlement? Or do they push back a lot?
It varies.
The first-time offenders that aren't aware that it's a problem.
It varies.
Okay,
And
all right.
it's not an automatic every time, oh, you got me. My concern is, especially amongst our licensees, we have this requirement of taking a 2-year, taking the Tennessee-specific ethics every 2 years, where this stuff is clearly gone over, and yet it's still, somehow it still gets through the cracks. But it does depend. It's case by case.
Okay, all right. Well, I would say if they push back, obviously they're not going to want to sign that form right away. We have to continue on through the process.
Well, then you also have the licensees that have, the liability insurance, their carrier. So even if there is some sort of citation that's sent to them, I think they still have to notify their carrier, who might have legal counsel involved at that point too. So there could be another kind of step.
Gotcha.
Okay, so we will work on that for the next meeting. Thank you, Rob. Other items of new business?
Mr. Chairman, I'd like to just say I appreciate you earlier mentioning the personal loss of 2 individuals very well known to this board, Art Sparks and Will Pugh, upon the passing of their spouses. And it caused me to recall the resolutions we did at our last meeting for Larry Elmore and Doug Warren. And I was just curious, do we routinely provide those resolutions to a spouse or family as part of that process? And if so, would we have done that?
I will try to answer that. And Jen, I will appreciate your help too. But as far as I know, those were the first 2 resolutions this board has done with respect to deceased members. Is there any?
I have both of those resolutions printed and framed upstairs, ready to hand to Greg to deliver.
But I think the question is, have we done resolutions in the past? I think those were maybe the first 2 that this board has done.
I know one was passed not related to a deceased board member, but a CPA applicant who was in the pipeline a few years ago. And I think that one was presented to the family, but I'm not aware of any other history besides that.
It was, and that's the only similar instance that I can think of. I'm not sure we've ever done a resolution, not that we can't or shouldn't,
Right.
for a non-CPA party.
Right. But we can certainly do that. We don't have a resolution prepared at this point, but it's a good question, good point.
Would it be appropriate for the board to just send a letter to Will and Art that we express our condolences and recognize such at our meeting today? You know, maybe not quite as formal as the whole resolution.
Sure, I'm good with that. Do you think, Jen, Reed, any comments? I mean, these are folks, as I mentioned earlier, who've done a lot for the accounting profession. Both Art Sparks, you saw Art's name on the TSCPA slides earlier, and certainly Will Pugh has done a tremendous amount for the profession. And yes, the loss of their spouses, but I think it would be meaningful to both Bill Pugh and Art Sparks to receive something from the board. So a letter would be great.
I will draft something, and Chairman, you and I can work on getting that to them.
Sounds great. Thank you, John. Any other new business? I should have mentioned this earlier, but when Reed was talking about cost allocations and so forth and our staff and team, I meant to once again thank our staff and team for the excellent work that you do. Karen and Jen are here, and Duke, and of course Lee helps us tremendously. I guess you're not officially part of the Board of Accountancy team, but you're certainly our legal representative. And but we have other members of the team who are not in this meeting. But just a thank you to all the members of the team. You do excellent work, and we're very appreciative of that.
Thank you. I have to brag on my team really quickly. So in this calendar year, so we have 4 individuals on our licensing team that report up, well, 3 that report up to Karen, me, and then Duke. In this calendar year, Leanne Blair, who's our education coordinator, was selected to attend the Tennessee Government Professionals Institute, which she attended earlier this year. Our team got to go to her graduation up at the library back in May. It was a really formal, fun event to recognize those individuals that had gone through that. And then Karen was recently selected to attend the Tennessee Government Management Institute, which is for individuals who are in kind of a middle management level with the state of Tennessee. Both of those are really great networking opportunities, cross-agency networking within, with other departments, other agencies in the state of Tennessee. And both of those are intensive leadership competency building programs. So we're really excited for Karen to attend that. It's a 2-week program coming up in the fall, and hear what her feedback is from that. But I'm really proud of them for being selected and agreeing to attend both of those.
Thank you, Jen. If there is no other new business, we will move to the public comment section. And I think, Karen, we have at least one request for public comment. Mr. Bryant?
No, actually, I was just signing in.
Oh, okay.
In attending my first meeting, I'm so impressed with the fairness of the board, the consistency of fairness, and all the work you do as a CPA, and thank you for letting me observe what you do.
Thank you for being with us today. Any others, Karen?
No, sir.
Okay. Then the chair would entertain a motion to adjourn this meeting. So moved. Do we have a second?
I'll second.
Second. Those in favor, aye, or leave. So thank you all very much, and have a wonderful afternoon.